I definitely believe this is not over. I do. I think he just said the quiet part out loud. And I think that is why we all must really understand the significance of what just happened.
With us now to talk more about this is Jim Obergefell, the lead plaintiff in the 2015 U.S. Supreme Court case that legalized same-sex marriage. He is also a candidate for state representative in Ohio. Jim, it's good to see you again. Despite what Justice Thomas said, Justice Alito wrote in the court's main opinion that the court emphasizes that this decision concerns the constitutional rights to abortion and no other right. What should we make of these conflicting messages?
Well, Jose, thank you for having me on. And I have to agree, it is conflicting for a couple of reasons. First off, Justice Thomas is clearly putting a target on the back of the right to birth control, the right to intimate relations, and the right to marriage. But I will say the thing that gives me a bit of hope in that is that all of the other justices in the majority on this ruling had the ability to add their names to Justice Thomas's concurring opinion. None of them chose to do that. So that gives us the ability to say, you other justices, we are holding your feet to the fire. You did not agree with Justice Thomas in this concurring opinion, and we are holding you to this. But on the other hand, I will also say these justices on the majority in this decision, during their confirmation hearings, they either said or implied that they considered Roe versus Wade settled law or precedents. Well, this decision in Dobbs clearly indicates that they were not being completely honest in those confirmation hearings. So even though the majority decision includes that word, that phrase, that this applies only to abortion and no other rights, including marriage, I find it hard to take a whole lot of comfort in that, given that they were not truthful during their confirmation hearings.
Yeah, I mean, what establishes a settled law or a precedent that the magistrates will consider to be sacrosanct?
That's a great question. And I look at the language, the rationale used in this decision, Jose, and I'm struck by the inconsistency and honestly the hypocrisy of the majority. They use the rationale that rights must be specifically written in the Constitution in order for them to be protected. And they also write that we can only interpret the Constitution as of the time it was written. Well, they are using that rationale inconsistently, those two rationales, and they're using it to protect rights that they personally believe in, but also take away rights that they personally do not believe in. And I will use the Second Amendment as an example. The Second Amendment clearly states well-regulated militia. However, they ignore those actual words in the Second Amendment, in the Constitution, in their decisions regarding the Second Amendment. And also, at the time it was written, in 1787, the framers of the Constitution could have never imagined automatic weapons. Their understanding of arms in 1787 were muskets, knives, and cannons. So this inconsistency and this hypocrisy in the rationale just, to me, is stunning and antithetical to what this court is supposed to do, and that's protect our constitutional rights equally and consistently.